Swayam Prabha. Digital India. Educated India.
Good morning students. My name is Shalini Sharma. I am working child right professional with an experience of more than 5 years as chairperson Child Welfare Committee and 1.5 years in my present role as member Juvenile Justice Board. Today I am here to take a course on Juvenile Justice Care and Protection of Children Act 2015. And this is our lecture number 4, and our module of the day is institutional care, or commonly known as child care institutions. In this we will study about kind of institutions for child in conflict with the law and the kind of institutions for children in need of care and protection. So students, in our previous lectures we have studied about evolution of juvenile justice system in India, and we have also studied about a statutory body called Child Welfare Committee, and we have also studied about another statutory body, Juvenile Justice Board, which deals with children in need of care and protection and in conflict with the law respectively. So today we will learn about the kind of institutions where such children can be placed if the need arises. To protect and provide care to children below 18 years of age from any form of abuse, exploitation and violence, Government of India has enacted a special law named Juvenile Justice Care and Protection of Children Act 2015. The legal obligations arising out of the Constitution of India and the international treaties ratified by India and other domestic laws on child protection possesses an obligation on the child care institutions under the Juvenile Justice Care and Protection of Children Act 2015 to ensure that every child in their care stays safe and that the rights of the children are respected, protected and fulfilled. The Juvenile Justice Act provides for the setting up of institutional care structures for children. The institutions are separate for children in need of care and protection and also for children in conflict with the law. In this section, we will try to understand what are these institutions, what are their functionings and how do they undertake the rehabilitation of children. As per international standards as well the Juvenile Justice Act, placing a child in institutional care should be the measure of last resort. Children are to be placed in institutions only when it is found that their restoration is not possible or when the restoration is not in their best interest. For example, institutional care becomes essential for child who do not have parents, whose parents are not suitable to raise him or whose parents are incapable or unable to take care of that child. Institutional care sometimes became mandatory for child in conflict with the law. It is necessary when the child is placed in a special home after being found guilty and placed in institutional care for reformation and reintegration by the orders of the Juvenile Justice Board. In some circumstances, CWCs and JJBs can order the child to be placed in institution or recognized by the government. The residential categories under which Juvenile Justice Board and CWC order for the placement of the child are divided into two categories. First, homes for children in need of care and protection, and homes for children in conflict with the law. Observation home, special home and place of safety are for the children in conflict with the law. Children home, open shelters and specialized adoption agencies, most commonly known as SARs, are for the children in need of care and protection. And there are two other facilities which are also used both by the CWCs and JJBs, which are fit person and fit facility. So, students, let us study about these institutions in detail. Observation home, section 2, subclause 40 and section 47, which says, an observation home, hereinafter
referred as OH,
is a child care facility that is for the temporary reception, care and rehabilitation of any child claimed to violate the law while an inquiry is pending upon him. And as per section 47 of the JJ Act, the state government shall create and operate observation home in each district or set of districts, either independently or through voluntary organizations or non-governmental organizations, which shall be registered under section 41 of this Act for temporary reception, care and rehabilitation of any child alleged to be in conflict with the law during the pendency of any inquiry. So, children, observation home is for the temporary reception, and that too when the inquiry is pending. So, let us see further. The Juvenile Justice Model Rules, rule number 29 says, the accommodation in observation home shall be as per the following criteria. Let us see what the criteria is. There should be separate observation homes for girls and boys. Classification and segregation of children according to their age group, preferably 7 to 11 years should be kept separate, 12 to 16 year age children should be kept separate, and 16 to 18 years children should be kept separate, giving due consideration to their physical and mental status and the nature of the offence being committed by them. Observation homes will be constructed in every district or a group of districts for the temporary reception, care and rehabilitation of any child believed to violate the law. So, the duty has been cast upon the central government and the state government to ensure that in every district or in a group of districts, there is one observation home for temporary lodgement of a child who has alleged or is proven to be conflict with the law. Rule number 9 of the Juvenile Justice Model Rule 2016 states that if a child cannot be brought before the Juvenile Justice Board or a single member due to odd hours or a distance, the child welfare police officer should hold the child in the observation home or a suitable facility and produce the child before the JJB within 24 hours after arrest. Here a duty is cast that if a child is apprehended at late hours and if its production is not possible before the member also, the child in conflict with the law should be kept safe in the observation home, and in no circumstances the child should be placed inside a jail or a police
lockup.
And if a child is denied bail, he or she may be placed in observation home by the Juvenile Justice Board. Now, the another kind of a home which is for the child in conflict with the law. Section 2, subclause 56 and section 48 covers the homes under special homes. A special home is an institution that is responsible for housing and providing rehabilitative services to children who have been found guilty of crime and ordered by the JJB or the Children's Court to be placed there as defined under section 2 subclause 56. So, children, we have studied that observation home is for temporary lodgement of a child. Now, we are studying special home, which says that if a child is found guilty of committing an offence, he can be placed in a special home. So, in a special home, child is placed for rehabilitative services, and that too by the order of the JJB or the Children's Court, but after having been found guilty. Now, let us see section 48 subclause 1 what it says. It states that state government to create and maintain special homes also in each district or group of districts, either independently or through volunteer organizations or non-governmental organizations, which shall be registered under this act. So, a duty is cast upon the state government to ensure that a special home, either the government opens it or it is opened by the non-governmental organizations, but one such home has to be in the district. Now, let us see what the rule 29 subclause 1 of the model rule says. The accommodation in special homes shall be as per the following criteria. A separate special home for girls above the age of 10 years and boys in the age group of 11 to 15 and 16 to 18 years. Classification and segregation of children on the basis of age and nature of offence and their mental and physical status. So, classification upon the age is prescribed, classification on the kind of offence they have committed is prescribed. The Juvenile Justice Board can send these young offenders to special home who have committed an offence. So, a special home, a child in conflict with law is sent when he has been found to
Have committed an offence.
after an inquiry. A child is placed in a special home only after the final judgment in the case of a child is given by the board. As I said earlier, after the inquiry, if the child is found guilty, he is sent to the special home. Now, let us see the third kind of institution, which is for the children in conflict with the law, and that is place of safety, which is covered under section 2 subclause 46 and section 49. Place of safety means any place or institution, not being a police lockup or jail, established separately or attached to an observation home or a special home, as the case may be, the person in charge of which is willing to receive and take care of the children alleged or found to be in conflict with law by an order of the board or the Children's Court, both during inquiry and ongoing rehabilitation after having been found guilty for a period and purposes specified in the order. So, children, in observation home, we sent a CCL when inquiry is pending and
Special home.
after a sentence is awarded, and in the place of safety. A child can be sent in both times, when the inquiry is pending or when a sentence is awarded. As if a child is between 16 to 18 years and he has been declared major by the court, and for that period his trial is going on in children court, he will be placed in a place of safety. Now, let us see what, as per section 49 of the JJ Act, the state government shall set at least one place of safety in a state registered under section 41, so as to place a person above the age of 18 years or child in conflict with the law who is between the age of 16 to 18 years and is accused
Of or convicted.
for committing a heinous offence. Every place of safety shall have a separate arrangement and facilities for stay of such children or persons during the process of inquiry, and children or persons convicted of committing an offence. The state government may by rules prescribe the type of places that can be designated as a place of safety under subsection 1 and the facilities and services that may be provided therein. A place of safety can be any place, but not being a police lockup or a jail. Here, as I said earlier, a child can be sent for both times, during inquiry and for ongoing rehabilitation by the order of the children court or by the board. And if a child has been declared adult by the JJB, the child will be placed with the place of safety. And in many cases, the case is pending before the senior courts where a claim of juvenility is raised. And while that claim is deliberated on, the child or that person is shifted to the place of. For persons above 18 years of age alleged to have committed offence when they were below the age of 18 years, pending inquiry. For persons above 18 years found to be involved in offences upon completion of inquiry. For children as per the order of the board under clause G of subsection 1 and section 18. For children, the age group of 16 to 18 years alleged to have committed heinous offence pending inquiry. For children, the age group of 16 to 18 years found to be involved in heinous offence upon completion of inquiry. So, these are the conditions when a child can be shifted to the place of
Safety.
After being found guilty, people can be held in safe facility while their case is being investigation and while they are being rehabilitated. For a person whose claim to be a child is being investigated and is required to be kept in protective custody, he is also placed in place of safety. The government of each state must create at least one place of safety as per the rules in section 41 to house individuals who are 18 or older or minors between 16 to 18 years who have been accused or found guilty of serious crimes. This facility must have different areas and amenities for the temporary stay of these young people who are facing inquiry and for those who have been sentenced for a crime. So, here a duty is cast upon the in charge and the government that this facility must maintain a difference between the children who are facing inquiry or the person who are facing inquiry or the children or the person who have been sentenced to a crime. Now, let us see what is fit facility and fit person. Under this act, the juvenile justice boards and the child welfare committees have discretionary powers in the best interest of the child to recognize and declare persons and institutions as fit persons and fit facilities, willing to temporarily receive a child for care, protection and the treatment, and that too for a specified period. Here two things are mandatory. The person or the institution should be willing to receive the child, and second, that care is for the temporary period. Now, let us understand in detail what is fit facility, which is described under section 2 subclause 27 and section 51. The Juvenile Justice Act allows for the temporary or short term placement of children in fit facility. Section 2 subclause 27 defines a fit facility as one that is managed by the government or by a voluntary organization and is prepared to care for a child temporarily or for a specific purpose. As per section 51 subclause 1, the board or the committee shall recognize a facility being run by a government organization or a voluntary or a non-governmental organization registered under any law for the time being in force to be fit or temporarily take the responsibility of a child for a specific purpose after due inquiry regarding the suitability of the facility and the organization to take care of the child in such manner as may be prescribed. So, as per section 51 subclause 1, The duty is cast upon the board or the committee to, after due inquiry and after taking due verification steps, to declare a person or a facility as a fit facility. The board or the committee may withdraw the recognition under the subsection 1 for reasons to be recorded in writing. If the board or the committee is of opinion that the fit facility is no more viable for the child, they have to issue an order, that too a speaking order, expressing the reasons why that recognition is taken back from that facility. The board or the committee can decide if an institution run by the government or a non-profit organization is good enough to look after a child for a little while or temporarily. They will check if the place is up to the mark before allowing them to take care of the child temporarily and declares it as a fit facility. So, as I explained earlier, duty of the board or the committee to verify the credentials of the facility, whether the facility is good enough to take care of the child. Now, let us try to understand the role of the fit facilities by two examples. For example, a child who is a drug dependent and with a substance abuse problem may be placed in a de-addiction center by the CWC or JJB. Now, there is no such institution in the home, but for the best interest of the child, the board or the committee can identify a facility and after verification declare that facility as a fit facility to receive the child temporarily for the care and the de-addiction services. Now, let us understand through second example. A hospital can be deemed as a fit facility if a child is suffering from a sickness that requires a special treatment or quarantine. If a child is found abandoned on the road and is suffering from high fever, the immediate need of the child is to be hospitalized. Since the child is abandoned and nobody is there to take care of him, the CWC or the board, as the case may be, identify a facility and after verification declare the facility as a fit facility to receive the child till the child gets well. Now, let us see what the model rules say about the fit facility. The board or the committee shall, on an application from any institution or organization run by government or NGO, recognize the facility as fit facility, provide the manager of that facility is willingly, temporarily to receive a child for specific purposes or for group foster care. As I explained, the board or committee, after receiving an application from an organization that we are willing to take care of the child, they can file an application to the board or committee to declare them as fit facility, and provided the manager of that institution should be willing happily to receive the child for his or her care. An application form in Form 38 shall be presented before the board or committee along with the bylaws, memorandum of association, list of governing bodies, list of trustees and other records, including their past record of social or public services they have encountered, should be submitted before the board or committee for the declaration as fit facility. Any facility or recognition as a fit facility shall meet the basic standards of care and protection to the child. So, this is very important. If a facility is able to meet the basic needs of the child, then only it can be declared as a fit facility. The fit facility is able to provide basic services to any child placed with it: good food, education, good air, sleep place, good clean washrooms, prevent child placed with it to any form of cruelty or exploitation or neglect or abuse of any kind. The board and the committee has to ensure that the fit facility is free from any cruelty or exploitation or neglect, that such behavior will not happen with the child if he is placed there. Abide by the orders passed by the board or the committee. This is also a very mandatory provision, that if a child is placed there, the facility has to abide by all the orders issued by the board or the committee. The recognition to an institution or an organization as a fit facility shall be initially for a period of 3 years, which may be renewed for a further period of 3 years in accordance with the subclause 4, and say that fit facility can be declared valid only for 3 years, but after it can be renewed. An institution or organization shall be recognized as a fit facility for purposes. And now committee and board would be requiring the services of the fit facilities, and now let us see in what cases they would be requiring the services of the fit facility. Short term care, medical care treatment and specialized treatment, psychiatric and mental health care, de-addiction and rehabilitation, education, vocational training and skill development, and witness
protection.
And so, these are the instances where the services of the fit facility would be required by the committee or the board, as the case may be. The services to be provided by the fit facility may include food, clothing, water, sanitation and hygiene for the child, mental health interventions including counseling, which is a mandatory aspect of Juvenile Justice Act. The facility should be able to provide counseling services to the child, medical facilities including first aid to facilitate specialized treatment, formal age appropriate education including bridge education and continuing education and life skill education, etc. The fit facility should also have the provision for recreation, sports, fine arts and group work activities. The placement of a child in a fit facility shall be for a period as deemed fit by the board or the committee or the children's court. As I have explained earlier, a child can only be temporarily placed with a fit facility. Now, let us see what the fit person is about. Section 2, subclause 28 and section 52, which defines fit persons. Fit person as per section 2, subsection 28 means any person prepared to own the responsibility of the child for specific purpose, and such person is identified by the committee or board. As per section 52, subclause 1, the board or the committee shall, after due verification of credentials, recognize any person fit to temporarily receive a child for care, protection and treatment of such child for a specified period and in the manner as may be prescribed. The board or committee, as the case may be, may withdraw the recognition granted under subsection 1 for reasons to be recorded in writing. So, the committee or the board, after due verification of the credentials of an independent person who has applied before the board or committee to be declared as a fit person, may declare him as fit person, and the committee and the board also has the power to withdraw that recognition back if that person does not comply with the directions of the board or the committee. Now, let us see what the JJ model rule 28 says about the fit person. Any individual who is fit to temporarily receive a child for care, protection or treatment for a period as may be necessary may be recognized by the board or the committee as fit person. So, fit person is also for a some time period. The board or the committee may identify a panel of persons on the basis of their credentials, respectability, expertise, professional qualification, experience of dealing with children and their willingness to receive the child, shall recognize them as fit persons for the purpose of this act. Now, children, a question must be arising in your mind, when we have children home, why do we need the facility of fit person? In some districts, we do not have the facility of children home, and let's assume a child is found at odd hours. Now the police duty
is to ensure that apprehended child is kept safe.
and difficulty of the police is that police cannot keep a child in the police station. So for the comfort of the child, a provision of fit person has been introduced, a provision of fit facility has been introduced, so that in the absence of children home in a district, the child can be temporarily placed with a fit person or a fit facility till the child is produced before the board or till the alternative mechanism has been developed by the board or the committee. Provided that such person should not have been accused an offence under the act or have been involved in any immoral act or in an act of a child abuse or employment of a child labour or in an offence involving moral turpitude. So, children, before declaring any person as a fit person, the board or the committee may ensure that such person is not involved in any immoral act of any child right violation act or employment of child labour or any offence involving moral turpitude. The board or the committee may also appoint any person as fit person on need basis for a child or children after verifying the credentials of such person and wherever possible after getting police verification done on such a person. So, before declaring a person as a fit person, rules make it specific that a police verification must be done of that person who wants to be declared as a fit person. The board or the committee may, if dissatisfied with the standard of care and protection provided or for any other reason at any time, by a reasoned order, withdraw the recognition of the person as a fit person from the date specified in the order of the board or the committee. So, it is the duty of the board or the committee to ensure that if a child is entrusted with the fit person, that person maintains the basic standards of care and protection, and if he violates that, the committee or the board has power to take the certificate of a fit person back from that person. Now, let us see the child care institutions for children in need of care and protection. The first such facility for CNCPs is open shelter. Section 2 subclause 41 and section 43 defines the open shelter. Open shelter. Section 2 subsection 41 of JJ Act says, a facility for children established and maintained by the state government either by itself or through a voluntary organization or NGO under subsection 1 of section 43 and registered as such for the purposes specified in that section. Now, let us see what the section 43 says. The state government may establish and maintain by itself or through a voluntary organization or NGOs as many open shelters as may be required, and such open shelters shall be registered as such in the manners as may be prescribed. So, the state government can open one or more open shelters depending upon the number of cases in that district. The open shelters shall function as a community based facility for children in need of residential support on short term basis with the objective of protecting them from abuse or weaning them or keeping them away from a life on the streets. So, open shelter homes will be like a welcome home to receive a child to keep him away from a street like situations. The open shelters shall send every month information in the manner as may be prescribed regarding children availing the services of the shelter to the district child protection unit and the committee. So, a duty has been cast upon the in charge of the open shelter to share the information with the district child protection unit and the concerned child welfare committee about the numbers of the children frequenting the open shelter home. Now, let us see what the rule 22 says about the open shelters. The open shelters shall be registered as provided under section 41. So, it is mandatory for all the open shelter homes to be get registered. All organizations and persons who wish to establish open shelters or already running open shelters shall make an application on form 27 to the state government for recognition. The services provided in the open shelters may include daycare and night residential facilities, including food, washing facilities, toilets and any other facility as the state government may deem fit. So, the open shelter should have all the facilities for the comfort of the child, like food, like for washing, like toilets and any other facilities like counseling or education should be provided to a child in open shelter. The open shelter shall not refuse admission to any CNCP at any time. The capacity of an open shelter should be such as to accommodate 25 to 50 children at one time, and it should also include a kitchen, dining facilities, bathrooms and toilets, lockers and recreational facilities. So, this clause has been added in the model rules to ensure the comfort of the child. A child can be found abandoned at any time of the day and any time of the night. So, a duty is cast upon the in charge of the open shelters that he or she cannot refuse entry to a child at any time of the day or night. In case where the agency in charge of the open shelter finds that a child may require more than short term care protection exceeding 24 hours, such child may be produced before the committee for appropriate further steps. If in charge open shelter comes to know about a case of a child that has not been identified by the parents or not visited by the parents for more than 24 hours, the in charge of the open shelter home shall immediately inform the committee about presence of such child in the open shelter home. The government of each state can create and run as many welcoming centers or open shelters as needed. These welcoming centers are meant to be friendly neighborhood places where kids who need temporary home can stay. We always see daily wages carrying their children along in the hazardous conditions. So, these open shelters offer such labor also. They can deposit their child in the morning and take him back at the time when they go back to their home after their daily work. The goal is to keep them safe from harm, help them to get off the streets, to prevent them from living on the streets in the first place. So, open shelters are open with an intention to keep children away from the street like situations and from the hazardous conditions. Now, let us see about the second kind of institution for children in need of care and protection, that is specialized adoption agency, which is covered under section 2 subclause 57 and section 65. Specialized adoption agency section 2 subclause 57 says an institution established by the state government or by a voluntary organization or NGO and recognized under section 65 for housing orphans, abandoned and surrendered children placed there by order of the committee for the purpose of adoption. So, children, here a child is placed for a specific purpose, that is for the adoption. If any child who has been declared legally free by the Child Welfare Committee will be placed in the specialized adoption agency for the adoption. Now, let us see what the section 65 of the JJ Act says. The state government shall recognize one or more institutions or organizations in each district as a SA in such manner as may be provided in the adoption regulations framed by the authority for the rehabilitation of orphaned, abandoned and surrendered children through adoption and non-institutional care. The state agency shall furnish the name, address and contact details of the SAs along with the copies of certificate or letter of recognition or renewal to authority as soon as the recognition or renewal is granted to such agencies. The state government shall get every SA inspected at least once in a year and take necessary remedial measures if required. So, it is the duty of the state government to inspect every SA at least once in a year, because children below 6 years are staying over there, and to ensure that the situations in the SA are comfortable according to the needs of the small children. In case any specialized adoption agency default in taking necessary steps on its part as provided in this Act or in the adoption regulations framed by the authority, such specialized adoption agency shall be punishable with a fine which may extend up to 50,000 rupees, and in case of repeated default, the recognition of the specialized adoption agency shall be withdrawn by the state government. So, this clause says, if anybody from the specialized adoption agency default in taking necessary steps as prescribed in the adoption regulation, he shall be punished with a fine which may extend up to 50,000 rupees, and in case if he repeats the offence, the recognition of the special adoption agency shall be taken back by the state government. Now, the third kind of institutions for the children in need of care and protection, that is Children's Home, Section 2, Subclause 19 JJ Act. It means children home established or maintained in every district or group of districts by the state government, either by itself or through a voluntary or non-governmental organization, and is registered as such for the purposes specified in the section 50. Now, let us see what the section 50 says. Section 50 subclause 1 says, the state government may establish and maintain in every district or group of districts, either by itself or through a voluntary organization or NGO, children home, which shall be registered for the placement of children in need of care and protection for their care, treatment, education, training, development and rehabilitation. So, students, if a child has been declared as a child in need of care and protection, he will be sent by the committee to the children home, and the children home will ensure all the basic needs of the child, care, his treatment, his education, training, development and rehabilitation. Subclause 2 of section 50 says, the state government shall designate any children home as a home fit for children with special needs, delivering specialized services depending on requirement. So, it is a duty of the state government to ensure that there is a recognized home for special abled children, and that home should be capable of providing specialized services for such child. The state government may by rules provide for the monitoring and management of children's home, including the standards and the nature of services to be provided by them based on the individual care plans for each child. So, children home has a duty to prepare the individual care plan of each child, and on the basis of those individual care plan, the kind of services required should be ensured by the state government. Now, let us see what the JJ model rule says about the children home. The number of posts in each category of staff shall be fixed on the basis of capacity of the institution, and it shall proportionately increase with the increase in the capacity of the institution. So, the staff should be directly proportional to the number of children staying in that institution. In case of a child care institution housing girls, only female person in charge and staff shall be appointed in that home. So, in a girl CCI, the whole staff should be female. Any person associated with the child care institution should not have been convicted of an offence or have been involved in any immoral act or any act of child abuse or employment of child labour or in an offence involving moral turpitude or hold any office in any political party during his tenure. So, any person involved with the child care institution should not be of any political party, should not be a person of a moral turpitude, should not ever have been involved in child labour, child abuse or employment of child in any circumstances. In case of institution housing infants, provision for ayahs and paramedical staff should also be made as per need. The security personnel shall deployed in the children home, taking into consideration strength of the children, age group, physical and mental status, segregation facility based on the nature of offences and structure of the institution. So, the number of security personnel required should be dependent on which age group of children are staying there, which kind of offence has been committed by the children, what are their physical and mental status, and as per their requirement the number of security personnel should be attached with that child care institution. The security personnel to be engaged or appointed shall be adequately trained and oriented to deal with the children with the sensitivity, preferably ex-servicemen or retired paramilitary personnel or through Director General of Resettlement. So, a guideline has been imposed that while engaging security persons for the child care institution, they should be those persons who are sensitive towards the child rights. They can be preferably ex-servicemen or a retired paramilitary personnel, or they can be requested to be given by the Director General of Resettlement. The security personnel should not be with arms or guns, but have a training and special skills to handle a crisis situation, control violence and escape of children from the institution, conduct search and frisking and security surveillance. So, the security personnel attached with the child care institution should not be given weapon or a gun, but he should be a trained personnel to handle any crisis or to handle a situation where a child is escaping or is able to do the frisking and the security surveillance. No person shall be appointed to work in a child care institution without police verification. So, the police verification for all the staff employed with the child care institutions, child care homes is made mandatory. Every institution shall have a management committee along with the children committee to be set up in a manner as may be prescribed to manage the institution and monitor the progress of every child. To prevent any kind of abuse of children in child care institution, the registration of these institutions have been made mandatory under the Juvenile Justice Act. It also helps to ensure that the standard of minimum care are provided by these institutions as mandated by the JJ Act. More importantly, if they remain unmonitored and stay beyond legislative purview, they can be dangerous for the safety and security of the children staying there. Compulsory registration of child care institutions. As children, we know that the institutions are very important part of the juvenile justice system and their mandatory registration is also provided. So, let us see what the section 2 subclause 51 says. Registered with reference to child care institutions or agencies or facilities managed by the state government or a voluntary non-governmental organization means observation homes, special homes, place of safety, children homes, open shelters or specialized adoption agencies, fit facility or any other institution that may come up in response to a particular need or agency or facility authorized shall be registered either on a short term or a long term basis, has to be registered. Now, let us see what the section 41 says. Registration of child care institutions. Notwithstanding anything contained in any other law for the time being in force, all institutions, whether run by the state government or by the voluntary non-governmental organizations which are meant either wholly or partially for housing children in need of care and protection or children in conflict with the law shall be registered under this Act in such manner as may be prescribed, regardless of whether they are receiving grants from the central government or, as the case may be, from the state government or not. So, section 41 subclause 1 says all institutions, whether they are run by the government or by the NGO, all institutions, either they are housing children for full term or they are housing children in a part time care. All institutions shall have to be registered. All institutions are to be mandatorily registered regardless whether they are receiving any grant from the government or not. They have to be registered under the JJ Act. Any institution housing children has to be registered, provided that the institution having valid registration under the Juvenile Justice Care and Protection of Children Act 2000 on the date of commencement of this Act shall be deemed to have been registered under this Act. So, a proviso has been given that if a child care institution has been registered with the earlier Act of 2000 will deemed to be registered under this Act also. At the time of registration under this Act, the state government shall, after considering the recommendations of the district magistrate, determine and record the capacity and purpose of the institution and shall register the institution as a children home, open shelter as the case may be. So, at the time of registration, a state government, after the recommendation of the district magistrate and inspecting the kind of facilities and also the capacity of the home, will decide to register that child care institution as open shelter, specialized adoption agency, observation home as the case may be, but only after the recommendation from the district magistrate and after evaluating the services provided by that institution. On receipt of application, registration under subsection 1 from an existing or a new institution housing children in need of care and protection or children in conflict with the law, the state government may grant provisional registration within 1 month from the date of the receipt of application for a maximum period of 6 months. So, if anybody goes and gives an application for the registration of his or her institution, the government may give that person a provisional registration which will remain valid for the period of 6 months, and provided that if in the period of 6 months the person is not able to fulfill the criteria for registration, that provisional registration will be taken back. If a state government does not issue a provisional registration certificate within 1 month from the date of application, the proof of receipt of application for registration shall be treated as provisional registration. So, if after the application the government has not provided the person with the provisional registration, the receipt of the application will be treated as provisional registration. If the application for registration is not disposed of within 6 months by any officer or officers of any state government, it shall be regarded as dereliction of duty. So, if a person has applied for the registration of his institution and after even 6 months the officer concerned has not taken any action or disposal of that application, that will amount to the dereliction of that fellow person's duty and the departmental proceedings will be initiated against that officer. The period of registration of an institution shall be for 5 years and it will be subject to renewal after every 5 years. The state government may, after following the procedure as may be prescribed, cancel or withhold. If the state government finds that the institution is not taking care of the reintegration services and rehabilitation services as mandated in the Act, they can take the registration back of such institution. Any childcare institution registered under this section shall be duty bound to admit children subject to the capacity of the institution. So, any childcare institution is duty bound to obey the orders of the committee, but a proviso is given: if there is no space, they cannot force to keep the child. Notwithstanding anything contained in any other law, under section 54, inspection committee has every right to visit the child care institution and give recommendations to the state government. Now, let us come to the conclusion, dear friends. Unfortunately, there are some children who, due to their age, socio-economic background, sex, physical and mental disabilities, becomes the victim of exploitation, abuse, violence and neglect, and falls out of the safety net of family care and protection. Therefore, in order to bring these children back, it is the duty of the state in its parents' patria role to ensure care and protection to such children. For this purpose, government is required to establish in each district children homes for both CNCP and CCL. Although we all know institutionalization of children is not preferred method, but sometimes it becomes inevitable due to certain practical difficulties. In conclusion, child care institutions are an important part of the juvenile justice ecosystem, but it is our duty to keep these institutions free from abuse and neglect. Thank you, children. I hope what I stated and all kinds of homes are clear to you by now. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.